I'm Doug Lichtman, and in this video, I want to think about who can be an author. In a prior video, I talked about what it means to be an author. Authors get the rights first. Authorships tell us how long the copyright lasts. Also tells us about this termination right. But here I want to think about who gets to be an author in copyright. And if we were just chatting about it, we might make an easy list and say, hey, maybe someone who originates expression. Maybe someone who brings forward the ideas that lead to the expressive work. Maybe it's someone who provides financing, equipment, space, motivation. Maybe it's someone who does something like taking a photo. We could brainstorm a lot of things. The law has struggled to make the official list. Like, what is it that makes you an author? And, well, let's start with some of the things we know. One thing we've said in the law pretty clearly is that an employer can be the author. And again, what this means is that an employer can get the rights by default. This is this idea of a work made for hire. And we can get some details from section 101. That's that definition section in the law. 101 tells us what a work made for hire is. And in the first prong, it says that a work made for hire is a work prepared by an employee in the scope of his or her employment. And maybe this is the easy prong. I start a company, I hire you to do something expressive, you're doing that work, and the law says, come on, we know where the rights should go. If the employer hired the employee to do this work, it makes sense that the rights go to the employer. That's got to be what the parties kind of by default meant to happen. That's wonderfully efficient. The employer can then do stuff with the work their employees create, and the cases then just struggle to figure out what's an employee. And we look at the intuitive stuff. We look at like tax treatment. We look at control. We look at the way you're paid. We look at decision making. You look at a bunch of things to understand, are you being tasked by the employer to do this, but shifting kind of the risk and the big picture decision making to the employer. Work made for hire prong one. Are you an employee? If so, your stuff is moved, the copyright is moved to the employer. That's prong one. Prong two is this giant mess of words. We'll only read a little bit of it, but it's for situations where it's not an employee, but it's an independent contractor. And so I'm not having you as my normal employee, but I'm still bringing you in for a project, and we want to allow the possibility that I, as the employer, can go get the rights. Here's how Congress wrote about it. They said a work made for hire might also be a work specially ordered or commissioned for use as a contribution to a collective work, as part of a motion picture, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas. And yes, I've always wondered, like, was there a lobbying organization in 1976 that went to Congress and said, atlases, we gotta be in the list, atlas. I don't know how that got in there, but it did. So great, it's a work that falls in one of these categories if the parties expressly agree in a written instrument signed by them that the work will be considered work made for hire. And so in this prong, we look for two things. You got to be in that bucket, one of those categories, and they're pretty flexible: collective work, motion picture, so on. Got to be in one of those buckets, but then you also have to have a signed document. And this is maybe not intuitive. You might have thought, like motion picture, you might have thought, gosh, the law would understand that in a motion picture, there are a lot of people who might look like authors. There's the producer, the director, the writer, the actors, the actresses, the lighting person, the makeup person, all these folks, on. And you might have thought copyright law might have been practical about this and said, if it's a motion picture, grab all those rights, and in the very first instance, give them to Paramount. And that's not quite what this law does. Because in that situation, they don't just snap your fingers, move to Paramount. I've got to have written contracts. Got to have everybody sign as they walk in, yes, I acknowledge this is work made for hire, signature. Then it all moves. But you have this step. Paramount's got to be paying attention. They do, of course. If you're ever on a movie set, as you walk in, you're asked to sign a bunch of stuff. One of the things is work made for hire, to move the rights to the employer. There's usually also a clause that says, in the event this fails and you accidentally are an author, you move ownership, you transfer ownership to Paramount. other things too, privacy and the like. But all I want to point out about the second prong is you've not only got to be in one of the categories, you also need this written document. All right, high level, who can be an author? Answer number one, me to you, employers. Just work your way through work made for hire, and then you get the rights by default. And reminder, they're not even vulnerable to termination. They're yours and you're done. Another way to be an author is to be the author of a joint work. And this is a little quirky, so let me say a sentence about it. We don't have a lot of cases that struggle with the question of who is an author when the factual context is easy. I sat down all by myself at my desk and I wrote a book. There aren't cases that then say, well, you're an author, and explain you did the expression by yourself. And there aren't cases because no one fights about that. We have a lot of cases by contrast about joint work. Because as you can imagine, a lot of people fight about joint work. We do something, it becomes successful, and all of a sudden a bunch of folks raise their hand and say, oh, I was an author of that, I'm one of the authors. And so we've had a lot of cases that are trying to sharpen who is and who isn't the author of a joint work. And that's helped us really think through the topic. Start in section 101, the definition of joint work. This is what Congress wrote. Congress wrote, a joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. Lots of words there. Prepared by two or more authors. They have an intent to merge their work. Now, I'm going to tell you what we're going to see in a minute, which is courts read that and said, that's nice, but that is way too broad. There's still so many examples out there where multiple people make contributions, merging them together. We gotta narrow this in some way. And so the court started to dig in to say, what else can we say to narrow what this seems to mean? And the court started by focusing on the contributions. What is it that you and I both gave that ended up in the joint work? My favorite case is a case where two people got together to write a play. One of those folks brought the ideas. They brought a ton of work. They brought a bunch of research. They brought a bunch of the necessary pieces to get this play written. The other person actually wrote the play. So the other person grabbed the pen, paper, and actually wrote the words and figured that piece out. So we had one person who brought ideas, hard work, they even brought money, and we had another person who did the straightforward, and not to belittle in any way, but the copyright clearly relevant expression. And they had a falling out, which is sad, and so the court had to ask, hey, wait a minute, are they both authors? Because one person brought ideas, hard work, and money, and the other person did this wonderful thing of bringing the expression. Are they both authors, or are we going to pick one of them? And the court looked at it and said, nope, nope, nope. Court said, copyright really values expression, and we're going to require an author to bring expression before we'll consider them for being an author of a joint work. And so in this instance, even though both parties were but for causes, you wouldn't have had this work unless you had both of them. And indeed, if we were sitting down and kind of measuring their contributions, I don't know who gave more or less to the final product, but the court said copyright law cares about expression quite heavily, maybe even primarily. And so if you want to say you're an author of a joint work, you have to have broad expression. And they said the other party gets nothing. Now, they could have gotten something by contract, sure. Had they realized at the start, they could have written down a deal to say you're the author, but now you're moving some rights to me. But if they didn't realize it, if they didn't foresee it, if they didn't have lawyers around, then the law in this case kind of famously said, to be an author, you must give expression. Step one. I'll point out to you, in the case, the problem wasn't Feist. Remember Feist, the case that said copyright only protects original works of authorship? And we said it means like creative expression and so on. That wasn't really the problem here, because there was an expressive work. There was a play. Yes, one party contributed the expression, the other party contributed all the other goodies, but Feist didn't really tell us the answer to this one, because there was expression, there was something to protect. We were just trying to figure out who gets ball control, who gets the rights. So I don't think Feist really tells us the answer. As I also note, it's a little bit weird in this case to look at the person who brought the ideas and the money, brought the hard work, and give them nothing. Because in work made for hire, the other category I've introduced to you, employers are people who give ideas and money, and right? We have no problem in work made for hire in saying that Marvel, the company, is the author of expression that their employee makes. That doesn't bother us at all. We recognize there are a lot of important ways to contribute, and we move rights to the employer. Here, in this case I've told you about, in this famous line of cases, the courts go the other way. It's not work made for hire, they don't do that analysis, and they then focus super heavily on who gave the expression. Fine, we have the definition from Congress about joint work. We have these first cases that say I'm looking for expression. Courts said that still isn't enough. They began to see cases where multiple people gave expression, and the court still wanted to say, no, you're not an author. And so they started to mine the language even more. They looked at the phrase two or more authors and started to ask, is authorship something bigger than giving expression? They looked at this language about intent, and what Congress wrote is the intent to merge, but the court started to say, maybe we want something more than that. We want intent to be authors of a joint work. And the famous case is a case involving the Spike Lee film, Malcolm X. And I want to show you a little bit of it because it'll really help anchor where the courts have gone as they tried to define what it means to be an author. And so here's a little bit of language from the case. In my slides, when I put the little quote and I put a symbol on the right, it's just telling you I've taken language from the court. Sometimes I edit it a little bit for clarity, but basically this is the language from the case. Here's what the court wrote. When interpreting a statute, we first look to the language. The statutory language, which we just looked at, establishes that for a work to be joint work, there must be 1, copyrightable work, 2, 2 or more authors, and 3, the authors must intend their contributions to be merged into an inseparable or interdependent whole. Great. A joint work in this circuit, where this case was being heard, a joint work in this circuit requires that each author make an independently copyright eligible contribution. And this is a nod to the case I just told you about. There were earlier cases where someone brought ideas and money and motivation and hard work, and the court had said, nope, not you. You have to bring expression. And so here in the Spike Lee case, the court says, we've already decided you have to, at a minimum, bring copyright eligible expression. Malcolm X, the movie, is a copyright eligible work. And the plaintiff in this case, a guy named Al-Muhammad, has submitted evidence that he rewrote several specific passages of dialogue that appeared in the movie. And let's just say a moment about Al-Muhammad. He was an advisor on the film, and he was super involved. Along the lines of giving ideas and putting in hard work and providing research, he was there to help them make a movie that rang true. He'd done such good work and been so involved that at the end of filming, Denzel Washington, who was the actor who played lead in the movie, Denzel Washington sent him a thank you note with a check for $200,000 as a bonus, as an acknowledgement. You really moved the needle for me, helped me make a good movie. He was the real deal, and importantly to this case, in addition to doing hard work and facts and research, he had contributed expression. He had helped to write some dialogue. And so under the prior line of cases, if all we look for is, did you give expression? Al-Muhammad said, yes, Spike Lee gave some stuff to this movie, and so did I. Al-Muhammad, therefore, has presented a genuine issue of fact as to whether or not he gave enough of a contribution that he can actually litigate to be an author of the movie. Court wants to say no. you know the court wants to say no. Because can you imagine the number of people who could make this argument on that film? If we let Al-Muhammad say, I gave some dialogue, and Denzel would then say, I messed up some dialogue, so I made it up while we were filming, that's mine, and writer, producer, so many people. The court wants to say, are old cases focused in giving expression? That is helpful, that's important, that's even necessary, but it's not enough. And this is what the court tells us. They say there's another element to a joint work. A joint work includes, quote, 2 or more authors. Al-Muhammad established that he contributed substantially to the film, but not that he was one of its authors. We hold in this case that authorship is required under the statutory definition, and that authorship is not the same thing as making a valuable and even copyright eligible contribution. We recognize that a contributor of an expression may be deemed to be the author of that expression for purposes of determining whether it's copyright eligible, which is to say, if the question were only, did you create a copyright eligible work? Maybe you wrote some dialogue. Maybe, yes. But the issue we deal with here is different, bigger. Is the contributor of expression an author of the movie? Bigger question. Under the definition, a joint work requires 2 or more authors. The word author is taken from the traditional activity of one person sitting at a desk with a pen and writing something. It's relatively easy to apply that word to a novel. It's also easy to apply that word to 2 people who work together in a traditional pen and ink way. But as the number of contributors grows and the work itself becomes less the product of a couple individuals, the word gets harder to apply. The court then goes on, so who can be considered the author of a movie? And we're not going to read this paragraph. All I want to show you is, look at this court. Eisenstein says this, the auteur theory tells us that, Grenier, I don't even know who Grenier is, but he has a suggestion, and then the great might perhaps be line. What you're seeing here is a court doing public policy. Some lawyer, and I don't say this critically, I kind of say this with admiration. Some lawyer walked in and said, look, if you just read what Congress wrote, Al-Muhammad's an author. 2 or more people, they tossed in expression, they wanted it merged together. If you just read the law and don't think about it, you're going to say that Al-Muhammad is one of the authors of the film. And that can't be right. And they convinced the court to lean back and think hard about more distinctions to draw. We're no longer in this paragraph parsing the words Congress wrote. We're looking around to understand, well, what would the world look like? What would happen if we recognize authorship on these facts? It's a lawyer doing his job, walking in, making room for the position that he or she really believes in. Here's where the court comes down. Court says, answering a different question, the Supreme Court in Feist, again, that phone book case, had said that some minimal level of creativity, originality is enough. But that measure of a work would be too broad and indeterminate to be useful if applied to a movie. So many people might qualify as an author that the test wouldn't distinguish one from another. Everyone from the producer and director to casting director, costumer, hairstylist, and so on gets listed in the credits because they all do make a real contribution. It's striking in Malcolm X how much the person who controlled the hue of the lighting in fact contributed. Yet no one would call that person an author. A creative contribution does not suffice to establish authorship. What does? Now the court is just giving us policy guidance. Here are the things the court thinks we ought to think about, and the court then applies it in this specific case at hand. Several factors suggest themselves as among the criteria we ought to use. First, an author superintends the work by exercising control. One thing we'll look at is who is really guiding the project. Second, putative co-authors make objective manifestations of a shared intent to be co-authors, which is to say, did they hold themselves out that way? Did they sign a contract that this is our joint work? Did they put a byline by Doug and Jim? Right? Is there some reason to believe from external evidence that they intended to be treated as the authors of a joint work? If not, maybe we're going to be skeptical that we should do it to them. Third, the court says the audience appeal of the work turns on both contributions, and the share of each can't be appraised. I don't love this one because it seems a little bit hard to prove in a bunch of instances, but the court is kind of groping for meaning. The expression you gave, was it non-trivial? Did it matter to the final work? Does it make sense to put you into a default role of an author rather than saying you get a 1%, 2% by contract? Right? We're trying to get a sense of who the real authors are, and this court is kind of brainstorming of things to watch for that would allow us to distinguish, in this case, Al-Muhammad from Spike Lee. Who can be an author? Someone who contributes sufficient expression to a solo project. I think that's the easy case. Someone who contributes sufficient expression with the requisite intent and other hallmarks for a joint work. That's our discussion of the play and then the Spike Lee movie. Or someone who qualifies as the owner of some work made for hire. These are the three big categories that we have a bunch of law to help us see those folks can be authors. There might be other folks too. We continue to get new cases all the time, but this gives us a framework, some analogies to draw when we're looking for, hey, who was the author? And this is super interesting now because we got to apply this to AI. And I'll go in a quick aside because it's really cool. Imagine you sit down with some AI system, you give it a prompt, and then it helps you write something. And when I say it helps you, imagine it writes it for you. And then imagine other versions. You go back and forth over time, or other versions, you ask it to write 12 versions of the paragraph, and you pick the one that you think is best. Think about the partnership between a person and an AI system. And now ask yourself, who's the author? Who gets rights by default? The old law tells us maybe we look for someone who contributes expression, although I don't love that analysis here, because that would mean that, ChatGPT is the author, which doesn't seem interesting or practical. To move the rights to the computer program? Are we moving it to the company behind the computer program? Are we moving it there on the assumption that they will then, by contract, move it to me and you, the people who ask the prompts? It seems a little silly to ask who gave the expression, but if we do ask that, I think it's the AI. Maybe we think about this as joint work. You, the person who asks the prompt, you, the person who evaluates the output, working together with the AI. Again, I'm not sure I love it. It elevates the AI to a powerful position that maybe the AI is like a typewriter or a word processor. Maybe we shouldn't be thinking of it as an author of joint work. Maybe the analogy is to the employer analogy. I actually really like this one, although at the moment at least the world doesn't seem to. But I really like this one because in work made for hire, we recognize that it's a practical question. We're assigning authorship thinking about what's going to happen next. That's why Marvel gets rights to its employees, comic book characters, because we know what's going to happen next is lots of comic books, graphic novels, movies, t-shirts. We're putting the rights where they can be used. And if we do that, I want to say the person who gives the prompt should be deemed the author. Even if they didn't do anything expressive, that doesn't bother me. That's what work made for hire does also. But if I can give it to that person, they will then pull out the good stuff, run up and tell us about it, invest in it, and the like. They gave the prompt, they gave the idea, they made it happen, and they can identify what output is worth disseminating. I kind of like that analogy myself. I'll point out to you, it might be that in the AI setting, we want to intentionally deny authorship so no one gets rights. The AI did the work, they did the expression, but we're not going to give rights to AI, therefore nothing. And if you like that story, you might like it as a way of weakening AI, weakening the rights that are available through that pathway. And so if I make a movie and I use AI, a story like this would mean I'm going to have a harder time monetizing that movie, which might pressure me to go do something more conventional, have normal people, not machines, do the expressive work. And so there is at least a line we should think about as to whether, on the one hand, we could assign authorship to make this stuff really useful. I'm certainly tempted to do that. But on the other hand, we might say, let's assign authorship in a way that makes it not so useful at all, i.e. don't give it or give it to the machine. Maybe that would be a way to slow down the AI revolution. Maybe. All right, purpose of this video, think about who can be an author. We have some high-level points to help us frame. We're watching for expression. We're watching for work made for hire. We have to focus a lot on joint work.